testimony is continuing today in the Alex Murdaugh murder trial, but today, Billy, we're almost seeing a trial within the trial. Let's bring our expert in and then we'll explain what we mean. Trial attorney Carl B. Grant. Carl, fascinating testimony today as the judge conducts hearings to determine whether testimony about alleged financial crimes will be introduced. So we've been able to hear this testimony. The lawyers, everybody in the courtroom, everybody watching online is hearing it. The jury has not yet heard it. Why is the prosecution fighting so hard to get this in?
Well, the prosecution is trying to keep its word. Remember, they promised the jury in their opening statement what their motive was. Financial crimes essentially was their motive, and they're trying to get that evidence in to make sure the jury doesn't say, well, they promised me this, but they didn't deliver. And if they don't deliver, trust me, the defense will take advantage of that, and they will point that out to the jury.
And Carl, at this point, how can that evidence be admitted if Alex Murdaugh has not been convicted of any of these financial crimes? Well,
here's how it works. Rule 404B is really a rule that keeps evidence out. It talks about other crimes, acts, bad acts, etc. Number one, they're generally not admissible. Okay, so you generally can't get them in, and especially if you're trying to offer them to prove somebody's character, bad character, you can't use it for that purpose. However, there are exceptions to that rule, and one of the exceptions is you can use the evidence to prove motive, and that's exactly what the prosecution is trying to do.
So what are the rules when it comes to admitting evidence? Because that's some of the jockeying that we're seeing in the courtroom as well between the attorneys.
It's a series of evaluations. Under Rule 401 of the Rules of Evidence, that's the definition. That's the one that deals with relevance, whether or not the evidence has any tendency to prove the guilt or innocence of the defendant in the courtroom. And if so, then the court will say, well, it's relevant. Now let's consider whether or not it's legally relevant. It may be logically relevant, but it might not be legally relevant under Rule 403, which is the balancing test that the court must do to determine if the evidence is indeed more substantially prejudicial than it is probative on the issue before the court. And then with this particular evidence, if the judge finds that it is relevant, then the court must determine by a clear and convincing evidence whether it even exists. First of all, if it's not relevant, that's it. That's the end of the story. And if it is relevant and it exists by clear and convincing evidence, the judge then goes back to Rule 403 to determine whether or not, when you balance it, whether it should come in anyhow. So the judge is in a serious issue here as far as trying to make that decision. And I noticed the court has asked the lawyers to come up with an agreement. In other words, if you all can come up with an agreement on this matter, I can go ahead and decide how I'm going to handle this. But it puts the defense in a tight position. Let me tell you why. The trial defense counsel has an obligation not just to defend his client and do his best to get justice on behalf of his client, but he must preserve the record for appeal. So if the defense counsel concedes to allow this evidence in, instead of standing firm on his position, it could be argued that he waived the issue for appeal.
That's a really good point, because I was wondering what would the incentive be for the defense to have that evidence admitted. I want to take our viewers into the courtroom earlier today where the former CFO of the law firm where Alex Murdaugh worked, she had some explosive testimony today. He was a part that stood out.
So tell me about June 7th. How does that go?
So on June 7th, I was going to make another run at finding out from Alex if we had their information. I went upstairs to his office is on the second floor, and he was leaning on a file cabinet outside his office. And he turned and looked at me when I came up and said, "What do you need now?" And gave me a very dirty look, not a look that I'd ever received from Alex, just kind of frustrated with me look, which made me go, "Oh, you want to know? Let's go in your office." So we went in the office and closed the door, and at that point I told him that I had reason to believe that he had received the funds himself and that I needed proof that he had not.
Received those fees himself?
Yes.
And I needed proof that they were not?
Yes.
What did he tell you?
He told me again that he assured me that the money was there and that he could get it.
So what we were listening to just now, to bring our viewers up to speed, that is the former chief financial officer of the law firm that Alex Murdaugh worked at. If you heard what she said at the beginning, she said she asked him about that on June 7th. Why does that date ring a bell? Well, that's the day that investigators discovered that Paul and Maggie had been murdered. So at this point, Alex Murdaugh, if this is admitted, and for the jury, he is kind of being painted as not a good character, as a liar. His alibi was busted yesterday. Where does this defense go to at this point?
Well, like I said earlier, though, the prosecution cannot use it for that purpose, as to prove bad character in order to prove his guilt. That's why they have clearly made it clear to the judge. They're not trying to use it for that purpose, Your Honor. We're just trying to use it to prove motive. Now, the question is the motive articulated by the prosecution logical, that he killed his family to hide financial transactions and the stress that came along with that? That's for the jury to decide. But that's the purpose in which he said he's going to use it, that is to prove motive. And so, let me explain one thing.
No, go ahead. Please do. Please do. Yeah.
What's going on now is what we call a proffer to the judge. The jury is outside of the courtroom, and you're giving the evidence to the judge, but the witness is not there for the judge to do a pre-screening, if you will, whether he's going to allow the jurors to even hear this evidence. And that's the process that's going on with all of these witnesses who are testifying outside of the court's presence. That's called a proffer.
So, Carl, the way the kids talk, what they say, she read him for filth today.
Right.
And she went down and listed, all of the money, and she didn't even try to, frame her language in a softened tone. I mean, she said he stole money. She said the firm had to pay back the money that he stole. I mean, and she went down. She even pointed out at one point to the prosecution, she said, you missed one, and went through and did that. If this evidence does get in front of the jury, how devastating will it be?
Well, at least the prosecution keeps his word that he was able to get arguable motive before the jury. Then again, the jurors still have to decide whether or not the motive makes any sense. They have to put it all together to determine, number one, the prosecution do they really need this evidence? That's the first thing, because like I said before, they don't even have to establish motive. So are they going to get bogged in the weeds in this particular evidence when they were already, in my opinion, had a situation with the witnesses that testified, they already had a strong case right before the jury. Now we're going from a roaring fire to a candle flicker.
Very interesting. One last question, because we are out of time. Any guideline you can give us in terms of how soon or how long you expect Judge Newman to take to make a decision?
I think if the judge decides to let any of this evidence in, it's going to be limited. I can't see him just allowing them to call maybe 100 witnesses and extend this trial out 2 weeks, 3 weeks, or even a month more. I don't see that happening. I see the judge making a decision to limit the amount of the evidence that may come in this category.
All right, you heard it here first.
All righty, Carl B. Grant, thank you so much for coming on the show and explaining that, breaking it down in a way that we can understand. So we'll be back tomorrow with more. For now, we're going to take a quick break, and we'll be right back.